my lady, I want to go to one other document, which is the Joint Cabinet Office National Archives document, called the Guidance on Management of Private Office Papers, page 212 in the supplementary bundle. I'll just make a couple of short points in relation to that. This guidance is all about what records should be created of government business within private offices. See for that purpose paragraph 2.
Sorry, could you just hang on 1 second?
Yes,
please?
sorry, Mark.
I'm afraid I seem to have...
203 of the 213 of the supplemental we're after.
No, that's not my problem. Yes, I'm afraid I'm going to have to close all this down and start again.
Shall we wait, because you might need it for the reply as well?
I'm afraid, otherwise I won't be able to see anything.
No, of course.
Hang on a second. It's computers for you. Can you turn that on and off again? Right. Do in the supplementary bundle page.
But it starts at page 212.
Thank you.
I want to draw your attention first to the paragraph 2.
Yeah.
You see the handling, first version handling, second version creation, clarifies one or two aspects. And then when you get to the passages that were relied upon, namely paragraphs 11 and 12, they're all about creation of records. So that's the first point. The bits that are actually relied upon are about the creation of government records, and as we saw from, for example, the Act, there's no duty under the Act, either PRA or Freedom of Information, to create any particular information or record. And it may well be that that's why the Divisional Court took the view that this wasn't 3-2 guidance. But be that as it may, the first point is that this is simply about the creation of records. And the second point to make about it is, as you see from paragraph 11, read as a whole, that is not a set of mandatory rules largely be concerned. In general, records should be created, and the language of should rather than must. And you will also see from paragraph 12 that there is a very significant and large number of exceptions that are created, including in particular 12 Roman 3 and 12 Roman 5. So all of that involves exercises of judgment and the good practice followed by lots of exercises of judgment as to whether it falls on one side of a difficult line or another side of a difficult line. It's a point that's been made already in this hearing. And all of that is at least disconsonant with the idea that this is a mandatory set of rules that have got to be enforced as a matter of law. It's just not apt territory for that, is the short point. But in terms of breach as an allegation, this is not mandatory in any event, even on its own terms. So that's what we say about the various documents to the extent that we engage in that exercise, and subject always to the procedural points I made before the short adjournment. I was going to turn finally to standing, which, as you recall, the Divisional Court didn't feel it necessary to deal with because of their prior conclusions, and given the stage that had been reached, it could only have been relevant to remedy anyway. But it does go to jurisdiction, effectively, even though it's a slightly strange exercise of going to jurisdiction. It goes to the jurisdiction of the court. See, for that purpose, Runnymede, paragraph 29, tab 45, page 1531, and it can be raised at any stage of the proceedings, not least because it may bear on or bar relief. See, for that purpose, Walton per Lord Reed at paragraph 95, tab 23, page 761. Runnymede, I'm sure the court is very familiar with, but the key message from Runnymede, we respectfully submit, is that whether a person is or is not directly affected by a decision, or by the decision under challenge, is a very important factor. It doesn't preclude NGOs bringing claims, but unless they're a representative organisation, it's likely they won't have standing unless the subject matter reflects a particular field of expertise which they, as it were, uniquely possess. And that was the approach that was applied in Runnymede to conclude that Good Law Project did not have standing in the context of that challenge. And we submit that that is an important and principal control on public interest standing and should serve to limit any circumstances in which you can just simply turn up and say it's in the public interest. The matter has also more recently been considered by Mr. Justice Waxman in another Good Law Project case, this time, or again, perhaps in the context of procurement, that is the Abingdon case. Again, I'm not going to go back to that, but it makes at least interesting reading because there's some quite extensive consideration of the various requirements of standing. And indeed, there's quite a lot of dissing, to use the vernacular, of the various lines of argument that are being advanced in precisely the same terms and form in this case, in the Abingdon case. That's at tab 47 behind page 1596. And just to give you the relevant paragraphs, because it's quite a long judgment and the standing bit happens right at the end. So the key paragraphs for the purposes of standing, you might want to look at some paragraphs for the purpose of seeing what the nature of the issues were, but the standing bit really starts at paragraph 498 and following, and there's about 4 or 5 pages considering the various standing factors by way of general background. But here...
Sorry, which page?
It's paragraph 498, and it's...
I didn't think there's that many pages. Maybe there are.
Sorry.
Yep.
It's 1686.
Yeah.
Sorry, I gave you the first page of the judgment. So it's 1686 and following. You see there's a section at the bottom saying standing.
Yeah, I got it.
And over there, for the next few pages, there's quite extensive analysis of why it is that they don't analyse by reference to the various grounds of claim that were made, why they didn't have standing in that case for any of them. But the interest is really in the extensive analysis of previous case law as a recent example, so that's helpful, we submit, alongside that Runnymede judgment that I referred to, which is Lord Justice Singh and Mr Justice Swift, I think, which is behind tab 45. So far as the present case is concerned, we make the following submissions. First of all, we submit that Good Law Project is no more representative here than it was in Runnymede. Here, as there, they're simply seeking to represent, in effect, the entire public in issues of interest to it. GLP plainly does not have a direct interest. It seeks to generate a direct interest in the litigation by asserting, and we submit it circular, by arguing that because it is litigating and may do so in the future on other matters, it has a direct interest in these issues because government records may have to be disclosed in that other litigation. So the fact that they have previously brought cases in which there has been a dispute about disclosure, for example, which may have required judicial resolution, is, we submit, neither here nor there. It doesn't generate direct interest any more than it would do for any other potential litigant to turn up and say, I have litigated for you. And this point was run in Abingdon and rejected as an argument. See page 1596. The start of that Abingdon judgment, and I've given you the relevant paragraphs from 1687 onwards, paragraph 500 to 550 are the key ones. But there the judge concluded, Mr Justice Waxman concluded, that GLP were not affected any more than any other member of the public. There were commercial operators out there in the context of that procurement challenge who could have challenged the decision. The court concluded that the claims were not of such gravity that they warranted any other approach. And the fact that GLP had brought a number of claims in connection with COVID spending could not be given anything other than very limited weight, where there was no, as they put it, as he put it, surrogate or associational claim, is the concept used or derived from Runnymede. That's paragraph 541 of Abingdon. But the mere fact that you're litigating can't possibly create a sufficiency of interest, or the vexatious litigant would have the best standing of all. And the position is not made any better by seeking, as they do in this set of proceedings and as they did in Abingdon, to say that they in part pursue what they describe as journalistic endeavours. We've made points in answer to that in our skeleton at paragraph 43E, and it was rejected as an argument in Abingdon at paragraph 543. So there's no more representative than it was in Runnymede for those reasons. But secondly, GLP's difficulty, if I may respectfully say so, on standing, at heart, is that as its own annual reports and litigation history reveals, it essentially exists to bring judicial reviews, essentially in any sphere that interests those who are running it. It's got no particular expertise from experience in any sphere, still less in the present context in relation to public records or means of government communication. And the only basis on which it sought to be tied in to their constitutional arrangements, as it were, is given in Miss Abbott's fourth statement of paragraph 29A, which says that the present claim is within the GLP strand of work call, quote, upholding democracy / governance. That isn't, we respectfully submit, an answer. It's an illustration of the core problem that is so broad as to cover everything, all public law errors, leaving entirely aside what basis there is for the claimed expertise in that sphere. And that was precisely the same observation in relation to the same reliance in the same terms in Abingdon, see paragraph 540. It is impossible, we submit, to derive from that activity or that description of its experience and expertise any expertise other than potentially in litigation itself. And that has the effect, if accepted, of collapsing the standing requirement into anything GLP wishes to sue about. So they say, well, there is a wide public interest in the policies and issues raised by the claim. That, in essence, would be an argument that the issues are such that anyone can and would have standing, regardless of their specialist interest or expertise. And that's definitely not the approach adopted and described as the correct approach by the divisional court in Runnymede. And that over-breath, that worry about pushing it out too far on that basis, has been reflected and remarked upon in a number of different proceedings in which the court has been involved. The Lord Chief Justice, Lord Burnett, prior to Runnymede and prior to Abingdon in GLP and the Minister for the Cabinet Office at paragraph 6, Authorities Bundle tab 42, page 1464, described the question of GLP standing in effect as a question ripe for review when it next arises. And you get similar sentiments about serious challenges and them needing to be addressed seriously from Lady Justice Carr in Good Law Project and the Secretary of State for Health at paragraph 70 in the Authorities Bundle at 1517. Thirdly, there is a significant number of better placed challengers, as in Abingdon. We've listed some of them at least in paragraph 43F for Freddie of our skeleton, up to and including the Information Commissioner. It's no answer to that to say that there are other better placed challengers but they haven't brought any claims. That point was dealt with when exactly the same argument was run in Runnymede at paragraph 31, page 1532, where the Divisional Court held that neither of the claimants had standing to advance a claim of indirect discrimination in relation to an employment decision because there were potentially personally affected individuals, quote, capable of bringing proceedings. And Mr. Justice Waxman again rejected a submission that a better placed challenger had to have actually brought a claim, otherwise the point was of no significance. He rejected that argument from GLP in Abingdon at 519, paras 519 to 523, page 1690. And fourthly, as I indicated earlier, the requirement of standing is a jurisdictional principle of law and oughtn't to be too readily circumvented. That is a point that was made expressly by the Divisional Court in Runnymede at paragraph 24, quoting from Lord Reid in AXA at paragraph 170. But the quote is set out in full from Lord Reid, so paragraph 24 of Runnymede is all you need. As I think Lord Reid put it in AXA, quote, the protection of the rule of law does not require that every allegation of unlawful conduct by a public authority must be examined by a court. Still less by any particular person brought in any particular way. The merits of the claim, fifthly and finally, is acknowledged in the case law to be of some relevance. And of course, depending on when the standing question is raised and resolved by the court, that may be more or less clear. If it's raised and considered at the beginning, it may not be terribly obvious because the court hasn't yet seen everything. But the further down the line you get, particularly when you get to the stage of the court writing its judgment, a fortiori, when you get to a court hearing an appeal, the merits are in a pretty decent state to be judged. And we submit for obvious reasons that doesn't help Good Law Project here. So for all of those reasons, we do submit that if you get to the stage of standing, and if you consider it right to produce something in your judgment on that, the correct conclusion is that Good Law Project does not have and did not have standing to bring this claim. My lords, my lady, those were my submissions, unless I can assist further.
Thank you very much. Ms. Kaufman.
I just get the computer in the right place. So going back to where Sir James began this morning, and that was with the PRA point and the construction of the PRA. In the course of those submissions, my Lord, the Master of the Rolls, correctly identified rather, that the emphasis of our submissions in the course of this appeal has been on the policies, including the SGB, regardless of their source. And so, strictly speaking, the source, and in particular whether the PRA creates the duty by which these arrangements were made, is irrelevant to the determination of the appeal. The only area where it is relevant is in relation to our argument with respect to Professor Bell, because it's only if Section 3.1 encompasses arrangements that, for ease of reference, include creating and preserving records which constitute a pool from which the ultimate records for preservation will be selected, that there can be any argument there is a duty to create records in relation to third parties who are engaged in government business. But that said, it does remain our case that Section 3.1, by necessary implication, requires arrangements to be made for the collection and then the preservation of records from which the ultimate selection for permanent preservation is going to be made. And for the simple reason that the legislation simply cannot work if there is not that duty that accompanies the express duty in Section 3.1. It is necessarily implied in order to give effect to that duty. And the fact that Parliament hasn't stated it expressly is neither here nor there. It's a matter of statutory construction that insofar as the court finds that a duty must of necessity be implied in order to give effect to the legislation, then that is what the legislation properly so construed requires. Equally, the fact that the way in which Section 3.1 is framed confers upon those who are under an obligation to make arrangements a very, very broad discretion as to what those arrangements actually are going to look like as and when made, is again absolutely no indication whatsoever that there was not an intent that those arrangements should be made. One has to simply think about pieces of empowering legislation which empower the Secretary of State to make regulations, for example, leaving him entirely, or her, free as to the nature and scope of those regulations, subject to however that discretion might be structured in the legislation. It is no indication that a broad discretion is conferred, that the arrangements are not required by virtue of that provision. What it means is simply that Parliament has decided that the question of what sorts of communications can be conducted for the purpose of generating records that themselves need to be recorded and preserved is something for the government, or for those who are responsible under Section 3.1. the way in which those records fall to be collected, the way in which they fall to be stored, all of that is something that Parliament has decided is entirely a matter for the person, official body upon whom the duty falls. But it in no sense implies or indicates that no such duty arises. And again, I come back to an answer I gave yesterday, which is it is not a duty to collect every single record. It is a duty to collect every single record which, on the basis of guidance issued by the keeper, constitutes the identifiable pool of documents from which preservation for ultimate permanent selection has to be made, must be preserved. It is specific to that. Now, how the arrangements then go about dealing with anything that doesn't fall within that pool is, again, entirely within the discretion of those whose job it is to make the arrangements. The Padfield point. It is no answer to the point that such a duty to make arrangements is necessarily implied to say that Padfield and the Padfield principle does not require that the actor whose actions frustrate the statutory purpose had that intent. It's no answer, because what this legislation requires is not an individual not frustrating its purpose. It positively requires steps to be taken to secure the effective implementation of its purpose. So again, Padfield simply doesn't touch why the arrangements, by necessarily implication, include policies of the kind that we are dealing with. So, ultimately, if the court, and putting aside the PRA point, if the court accepts that these policies, whether collectively, some of them, or in some policies, they do both of these things, but if the court accepts that the policies have two requirements built into them, one, a clear prohibition on the use of private devices and private communication systems, and two, that where any such devices or communication systems are used, a requirement that the information thereby generated, insofar as it relates to government business, must be proactively moved onto and stored in approved government depositories, then the question for this court is simply this: why, if the court so finds, these policies should not be subject to the duty of compliance? And I'm going to just encapsulate the duty that we've been speaking of as, or that is an issue in this case, as the duty of compliance, just for ease of reference. And if, in fact, this the source of these policies is not the statute, then what we have is a series of policies either made ancillary to the Public Records Act, or made under common law powers, or made under the prerogative, which constitute the settled view of the government as to how it is to ensure that documents relating to government business are generated, stored, and preserved for purposes which include transparency and accountability, whether that transparency and accountability be pursuant to its obligations under the Public Records Act, whether it be transparency and accountability pursuant to the Freedom of Information Act, whether it be transparency and accountability pursuant to any public inquiries that may arise in the future, such as the current COVID inquiry. And the question then is, why should such an important policy, not an internal facing policy, a policy with such constitutional importance, I don't say that lightly, that's exactly what these policies are. They are the guarantors of transparency and accountability. Why should those policies that the government has issued in order that its staff and officials comply with it, in order to assure democratic accountability, not be subject to a principle already recognised in public law, and that is the duty of compliance, the purpose of which is to support and ensure good administration, and the purpose of which is therefore to further good governance. That's the fundamental question this court is presented with. And interestingly, when we look at the law in relation to, public law in relation to policies, the respondent and the appellant's first port of call is precisely the same authority, but seemingly for opposite effect. We both rely upon the Secretary of State for the Home Department. I took the court yesterday to paragraphs 2 to 3. I do think it's worth coming back to it, unless the court would find that unhelpful. But I think it really does encapsulate a very, very important starting point in a number of respects. It is at tab 38, and we are looking at paragraphs 2 to 3.
1315.
1315. And if you'll forgive me, I'm going to read paragraphs 2 and part of paragraph 3 aloud, just so that I can stop and then focus on matters that are of some significance to our arguments. It's a familiar feature of public law that ministers and other public authorities often have wide discretionary powers to exercise. Usually these are conferred by statute, but in the case of ministers, they may derive from common law or prerogative powers of the Crown, which fall to be exercised by them or on their advice. And we could add here, or third source powers. Where public authorities have wide discretionary powers, they may find it helpful to promulgate policy documents to give guidance about how they may use those powers in practice. Policies promote a number of objectives. In particular, where a number of officials all have to exercise the same discretionary powers in a stream of individual cases which come before them, a policy may provide them with guidance so that they apply the powers in similar ways and the risk of arbitrary or capricious differences of outcomes is reduced. Now that is the way in which policies can support good administration. They encourage consistency, and they encourage consistency whatever the policy.
So what's the power here? What is the power here?
In this case?
Yes.
Well, the power is third source powers, the prerogative.
Now, what's the discretionary power that this policy goes to?
It is a discretionary power that the government has, qua, or ministers have, qua ministers, that are either ancillary to and supportive of, for example, the PRA or FOIA, or they are simply aspects of the residual powers left to them under the common law to be able to do that which a private person might themselves be able to do. Query whether or not the exercise of those powers is then limited in relation to the government, such that they must exercise those for the public good. That's the point that we saw yesterday was not settled in the Shrewsbury case. But there's no dispute between the parties that there is the power to do this, and the power will be a discretionary power, not structured, not confined, save to the extent that it arises under Section 3.
But what is it a power actually to do?
Well, here it is a power to regulate the way in which information generated in the course of government decision making is stored, it is collected, stored and preserved for and in support of transparency and accountability, for and in support of legal obligations such as the Freedom of Information Act obligations and the Public Records Act obligations, for and in support of security, see the SGB. That is the nature of the discretionary power that has been exercised. And those are the purposes for which it has been exercised. So those are the public law, or rather the administrative and governmental goods for which government itself resorts to policy making. And the principles of public law that have been generated by the courts in relation to policies, which is not to give legal effect to policies as law, but which is simply to regulate policy making, have all been done in order to support good governance and good administration in government. So we then see, we've had the promotion, consistency, preventing arbitrary or capricious differences in outcome. And then we can see they go on and say, if placed in the public domain, they can help individuals to understand how discretionary powers are likely to be exercised in their situations and can provide standards against which public authorities are held to account. Now, that's when they are placed in the public domain. But the previous identification of how policies are beneficial to good governance has nothing to do with whether they're put in the public domain or not. And then we get at 3. They are different from law. And what that means is a policy is not a rule of law. Now, the respondent keeps mischaracterising our case as one in which we are seeking to elevate a policy into a rule of law. We don't do anything of the kind. We are relying upon a principle of public law to the effect that a policy, whilst it continues to be in existence, insofar as it creates obligations which are clear and identifiable and unambiguous, then it is to be followed and applied by those to whom it applies, unless there are good reasons to depart. It's not a rule of law. It doesn't give legal effect to the policy. It is a principle of judicial review which...
Sorry to interrupt. Sorry, I thought you finished. Can I just ask about that policy, which and principle you say in public law? That would actually apply if there was a policy that all civil servants must work in this room between 9 and 10, and you go out of the room. It's clear, according to you, it's a policy which is in existence. It's created an obligation to stay in this room, and it should be followed unless there's a good reason to depart.
No.
You go out to have a cigarette, which is not a good reason. Why is that not? What principle do you rely on to show that that's not?
So the principle we rely upon is it is only those policies which constitute the exercise of the kind of power that is susceptible to judicial review that will themselves be subject to the duty of compliance. So can I come to, for example, the example given by Sir James this morning of the double-sided pages, or the example you have given, or the examples I gave yesterday about how often computers are renewed, or whether you use single-sided paper. Those sorts of administrative or employment relationship, pure employment relationship powers are not the exercise of a public power in the sense that I refer to. And the distinction that it's useful to have in mind is between a corporation, for example, and the kinds of powers that a corporation can exercise in respect of its employees or its internal administration. And if the kind of policy you're looking at, or the bit of the policy you're looking at, is concerned with regulating that sort of conduct, i.e. it's no different from what any private corporation or employer could do, then that is not the exercise of a governmental power. We are specifically talking about the exercise of powers that impact upon the public and are done in the public interest. So that's why this policy unquestionably falls, even though there may be elements of this policy, such as, I think, something that Sir James referred to this morning, that he characterised as the same as using double-sided paper. There may be elements of this that simply do not constitute the exercise of public power, just as in relation to the SGB, the Ministerial Code, the court identified that there may be bits of that policy that are non-justiciable, whereas there are other bits that are justiciable. So no, not all policies, but very many, I will readily accept, very many policies that are issued and promulgated by public authorities proper would be subject, we submit, to the duty to comply for precisely the reason that they do constitute the exercise of governmental power. So that's a critical part of our argument. So we turn then, if we can just turn back then to this, so they've articulated how policies are different from law, and they then note it in an important development in public law in the last decades that courts have given policies greater legal effect. That's the point. It's not turned them into rules of law. They have given them greater legal effect. They have subjected them to various public law principles. And they then identify one of which being acts between C and D if the policy is not made public and an affected individual is unaware of its relevance to his case and in that sense has no actual expectation arising from it. And it's important, we will get away from legitimate expectation more clearly when we look at Mandelier. The authority may still be required to comply with it unless able to justify departing from it. So that duty of compliance is cited here as an instance of giving more legal effect to policies. It's not the creation of a rule of law, or rather it's not that a policy becomes a rule of law, it is the way in which legal effect is given to a policy through the duty of compliance. So we do rely very strongly on paragraphs 2 and 3 as setting out very clearly the way in which the law or the principles of judicial review have developed in the last decade to give more effect to policies. So the question then is, why should that duty of compliance be limited only in the way that the Divisional Court identified to policies that impact upon the legal rights of an individual? And we are taken then necessarily to Mandelier and to paragraph 29 of Mandelier. I'm afraid we do have to look at it again quite carefully. It's only one paragraph. It's page 965, paragraph 29.
Sorry, Ms. Cullen, can you remind me which tab it is, please?
It is at tab 27.
Thank you.
And this is important because, and I'm going to ask the court to read it itself, but I want the court to take 2 points from it. First, what the Supreme Court does in this case is it detaches the duty of compliance from the legal principle of legitimate expectation. It reverses the wrong turn that the law has taken, and it makes it absolutely plain this is not an aspect of legitimate expectation or an emanation of legitimate expectation. And the reason it does that is because you cannot found a principle that applies whether or not the person knows that the policy is even in existence. You cannot marry that with legitimate expectation, because legitimate expectation necessarily requires that the individual is aware and therefore has an expectation and to some extent relies upon the expectation given from their awareness. And that's why it is released and fully released in Mandelier. And then we see the Supreme Court adopting a clear and a foundation, an already existent foundation. We saw that from Amatsa yesterday. But the foundation for this principle is identified in the quoted passage from Lord Justice Laws, as he then was, where he says, at the bottom of that quoted paragraph, I would prefer to express it rather more broadly as a requirement of good administration by which public bodies ought to deal straightforwardly and consistently with the public. So the principle identified is the duty of compliance. Its normative justification or foundation is good administration, an aspect of which is consistency and dealing straightforwardly with the public, another aspect of which is avoiding arbitrary decision making. See paragraphs 2 and 3 of A and the Secretary of State for the Home Department. So that is the foundation. And can I, just before moving on, bring us to the case of Gallagher? because this was a case to which Sir James made reference earlier on. He didn't take you to it, but the point he was making was that in Gallagher, the Supreme Court said in terms, the principle of equality is not a freestanding principle of judicial review. And he's deploying that as a criticism, seemingly, of what we are attempting to invite this court to do. That is, by extension, to make the principle of consistency, or the principle of avoiding arbitrary decision-making, freestanding principles of judicial review. That's not what we're doing. The principle of judicial review is the duty of compliance. Its foundation, its normative justification, lies in good administration and the virtues of consistency and so forth. But the principle of judicial review, the freestanding principle, is the duty of compliance. And we can see how this works, for example, in the case of ZLL, in paragraph 7.4, it's tab 46. This is a recent decision of Mr. Justice Fordham, and in his usual style, Mr. Justice Fordham at paragraph 7 has identified, it's page 1565, here are some basic legal points relevant to ground 1. Basic legal points, he describes them. And this is all about policies. So if we go down to paragraph 4, he gives the various principles that have been identified by the courts in relation to policies over the last decade. Some easy descriptors. The duty of prescription point. It's a recognised feature of public law that there are contexts in which it is legally necessary for public authority powers to be circumscribed by means of the issuing of prescriptive policy guidance, i.e., there are some situations in which a decision maker actually has to formulate policies. And what he then says at the bottom of that paragraph is, as can be seen from those passages, this is the 4th line from the bottom of paragraph 7.4, as can be seen from those passages, the underpinning of the public law duty to issue prescriptive policy guidance, guiding the exercise of discretionary powers, is a recognition of the virtues of consistency and protection against arbitrariness. Precisely the same in relation to the duty of compliance. The underpinning of the public law duty is good administration and the virtues that protects in consistency and the avoidance of protection against arbitrariness, and where it affects individuals, equality of treatment and so forth. So that is how we rely upon the underpinning virtues, but they are not freestanding doctrines.
So is your duty of compliance the same as Mr. Justice Fordham's duty of conformity?
Our duty of compliance is exactly the same as the duty of conformity, exactly. And notably, what he does with the duty of conformity is he puts that there as 7.4, and then, and note, there is nothing there that indicates that this is a duty limited in any sense to decisions that affect individual rights. It is a general duty of conformity in respect of principles, policies. And then there is an entitlement of conformity at 7.8, which is simply making the point that when you do have a policy that affects an individual, then there is going to be a corresponding entitlement to conformity. But it's not thereby circumscribing the duty of conformity, which is described in the previous paragraph. So the defendant, the respondent, Sir James, earlier in his reply this morning, sought again to urge this court to take care not to overstep constitutional boundaries in the way it addresses the nature and scope of this particular duty. And your lordships would, yes. And the arguments that were put forward is that, and this is also clear in their skeleton, It undermines the role of Parliament and the separation of powers by giving to public authorities a general ability to create a form of rules of law without any statutory basis or control. Well, that is simply wrong. There is no creation of a form of rules. It does not create legal rules. It is simply a principle by which effect is given to policies.
It's odd that it doesn't create legal rules if you're asking for a declaration that what happened was unlawful.
No. The duty of compliance does not turn a policy into a law. It doesn't alter the status of a policy and give it legal effect as law. It requires individuals to whom that policy applies to comply with it, absent good reason. That is in no sense trespassing.
And if they don't, it's unlawful.
Yes, if there is no good reason, but that's not to turn the policy into a rule of law.
Well, what's the law then that they're unlawfully doing? I mean,
What they're unlawfully
you can't have
doing-
it both ways. You can't have it as unlawful if you haven't got a law.
It is unlawful. The law is the common law principle that you must comply with a policy absent good reason not to do so. That is the rule of law. That is the rule of law, and it is a common law principle of public law. It does not turn the policy itself into a rule of law, and that is the complaint of the respondent, and that complaint is simply wrong. It doesn't do that. But there is a rule of law. Of course there's a rule of law. That's what we're relying on, and that's why we say these failures to comply are unlawful, because they do not comply with the rule of law that policies must be complied with absent good reason.
But your argument effectively is if you create a policy, quote unquote, whatever that means, leave that on one side, you are creating a rod for your own back because you're subjecting yourself to what you say is a rule of law, which is that you must comply with it unless you've got good reason for departing.
Oh, in that sense, you're creating a rod for your own back, but that's not the complaint that the respondent makes. The respondent's complaint is that it undermines the role of Parliament and the separation of powers, and it simply does not do that. And the fact is, the court has already recognised that by making policies, governments are creating a rod for their own back because it has already recognised the duty of compliance. And the reason it's created that rule is precisely to facilitate good governance, and therefore the wider ambit of the rule of law, where that concept is used in a broader sense than simply complying with statute. Now, the other complaint put forward by the respondent was that it too readily requires the courts to engage in matters of policy directly, with the sorts of implications deprecated by the court in A in the Secretary of State for the Home Department of paragraph 40. Now, in my submission, again, that is wrong. It is not requiring the court to engage with policy in the sense that it is asked to look at and criticise in any sense or question in any sense the substance of policy. On the contrary, yes, it has to construe policy, but it will always have to construe policy where it has any legal effect, but only in order to give those terms of the policy effect. So there's nothing incompatible and inconsistent with what the Supreme Court in A was concerned about. That was a very, very different concern that the Supreme Court was there expressing, because what was in issue there was the question of whether or not a policy sufficiently, in substance, was drafted so as to avoid the risk of unlawful decision making. And of course, if articulated, the principle of judicial review as one whereby there is a duty in the terms of the policy to avoid a risk of unlawful decision making, then of necessity the court must embark upon a minute, or in some cases, inquiry as to whether or not the substantive terms of the policy do that. And if they don't, then they're going to have to be altered and changed. And what the Supreme Court was extremely concerned to ensure that our courts do not do was to engage in some sort of legislative drafting process in relation to policies. We're nowhere near that. We're simply asking the court to give effect to the respondent's own policies, unless there's good reason not to do so.
If you're finished with Mr. Justice Fordham's judgment, can I just ask you about 7.7 and the duty of conformity? He doesn't appear there to restrict it as you restricted it to an exercise of governmental power. I mean, I imagine you just say, well, these are not statutes, these are just expressions.
That's just a judgment. He's just taking it as given that it's only going to be where the policy is of the kind that's subject to judicial review. So if it's not a policy of the kind subject to judicial review, then the question simply doesn't arise. That wasn't an issue in that case.
No, I appreciate that, but it's sometimes a difficulty which arises if you then set out what you say is the law, if you then don't qualify it. Anyway, doesn't matter.
So, can I then come back to points made by my learned friend this morning? So, firstly, he said that what we have here, one of the reasons to confine the policy in the way that they argue for, is that it itself, the duty of compliance, recognised in Mandelier, is but a small and incremental extension of legitimate expectation. Well, I've already made the submission that it has nothing to do with legitimate expectation, and it has completely divorced the basis of this policy and the principles that give rise to it from legitimate expectation. So that feature of legitimate expectation, which rests upon the policy in question having an effect on an individual, has no role to play and is not a reason, therefore, to limit the application of this duty in that way.
Was it right to say that the Supreme Court's completely divorced this from legitimate expectation, or rather, might it be more accurate to say what the Supreme Court has done is to extended the cases in which this approach applies to cases where the policy hasn't been published, and therefore to a case in which the person concerned didn't have a legitimate expectation?
Well, my lady, my reading of it is that it frees it, and in my submission that is the only sensible
In
way
every
to read
case,
it.
or just on the facts of that case?
I'm sorry?
In every case, or just on the facts of that case?
No, in every case, it makes clear what the principal basis is. It makes clear there has been a wrong turn, and it is no longer to be understood to be a principle that is a feature of the principles relating to legitimate expectation.
But it's a massive expansion. If you take it from individual rights to every policy in every area.
It's not a massive expansion. One has to ask, what's the principal basis for not doing it? You have to look at why the principle exists in the first place, and one has to ask oneself, given its foundation in good administration, securing consistency and so forth, why should this policy not apply to all government policy making, which is the exercise of an executive power?
Let me put this to you. The paragraph 29 of Mandalia, if it approves on behalf of the Supreme Court, Lord Justice Law's dicta, is at least difficult to reconcile with A and the approach in A, is it not?
In my submission, it's not in the
Because
least difficult.
Lord Justice Laws puts it very widely, talking about any area. I mean, I haven't got it in front of me. We can get it out.
But the facts of Nadaraja concerned a policy that had an impact on an individual. So you can't divorce the dicta in Nadaraja from the facts of that case. He didn't mean anybody anywhere can rely on the policy.
These decisions have arisen in the particular context where they were brought by individuals who were affected by policies.
Yeah,
but in no sense is the underlying justification, and the one in particular recognised by the Supreme Court in Mandelier, restricted to and explicable on the basis that individuals are affected. It is a principled justification that applies equally to policies that are general exercises of public power that affect the public in general, which can include extremely significant effects and be of great significance.
Well,
And
I mean,
of
the
great-
principle that they espouse in Nadaraja, looking at it now, is said even by Lord Wilson to be related to the doctrine of legitimate expectation, which, as my lady indicates, is all about individual rights, the legitimate expectation of individuals. And so it can't just be detached in the way you say, particularly when read with paragraphs 2, 3 and 40 of A.
But in my submission, there is nothing in paragraphs 2 and 3 and 40 of A that would indicate that this principle is confined, must be confined, should be confined to its impact upon an individual.
Okay.
And if that is the starting point, then the fact that this is a principle that has evolved in the context of individuals bringing challenges is simply an explanation of the genesis and the development of the policy. But it is not that factual circumstance does not constrain and limit the application of the policy. And critically, nowhere is it said that it does. So again, we have to come back to what is the principled justification.
Well, it wasn't. Nobody said otherwise, because nobody was suggesting in Mandalia that the particular policy, the instructions to caseworkers that wasn't published, could have any impact other than on the people who made applications that were covered by the instruction to caseworkers. I just don't see how you can develop from the reasoning in Mandalia a general principle that policies are generally enforceable. I just don't see how it works.
Well, I mean, I am now at the point of repeating myself.
Yeah.
In my submission, it works for the very reason that the underlying principle, the normative foundation identified in Mandalia of why the duty of compliance exists, is one which is not in its nature limited to decisions that affect individuals. It is a principle that applies equally to all government policies and serves good administration in relation to decision making in the formulation of all such policies. And then one has to come up with a reason why either it has been said in terms by the court, this only applies in this way, in which case you are bound. There is no such reasoning in any of these cases. Or one has to come up with a principled basis for so restricting it. And in our submission, there is no principled basis. I went through yesterday all the concerns and the reasons given by the court as to why this should be so limited. I'm not going to repeat those now. So many of those were relied upon by Sir James today. I have the same answers as I gave yesterday. They simply do not provide a principled basis on which to narrow the scope of this. And so far as the concerns that the court were raising yesterday about these particular policies, well, we've addressed those concerns in our note this morning. I'm not going to repeat that here. But concerns that exist about how this is going to either tie the courts up or bind government decision makers are easily met either by the courts using their panoply of powers in relation to standing, in relation to relief, or by the decision makers addressing the problems that compliance or a duty of compliance gives rise to by changing their policies. But none of that provides a justification for this court not taking a principled and coherent approach to the development and articulation of administrative law. And there simply isn't. The very facts, the simple fact that these have all been cases which have arisen in the context of individual rights where there is nowhere any statement that it is only in that context that these cases...
Well, that's what I wanted to ask you about. And, I mean, it's a question which we may have been round before, but you asked us to read very carefully 2 and 3 of A, and I have done so now many times, as perhaps we all have. And in the fifth line of paragraph 3, Lords Sales and Burnett say, an important development, however, having said rules are different from law, policies are different from law, an important development in public law, principles of public law, in the last decades, the courts have given policies greater legal effect. And then they say what that is. In certain circumstances, a policy may give rise to a legitimate expectation that a public authority will follow a particular procedure before taking a decision, and it may give rise to a legitimate expectation, the term is used twice, I note, that the authority will confer a particular substantive benefit when it does decide how to exercise its discretion. In these cases, the courts will give effect to it, unless, same old, and then the Mandalia exception, if the policy is not made public, the authority may still be required to comply with. So that seems to be a statement that this is all about the certain circumstances where there is a legitimate expectation, or exceptionally, the same applies if the policy is not made public. It doesn't seem to broaden the horizon from individual rights, which you're seeking to place in the wide words of Lord Justice laws.
Yes, because this is simply citing Mandalia. It's not purporting to change what Mandalia decided. So you have to go back to Mandalia and you have to see what did Mandalia decide. And Mandalia has extracted the duty of compliance from its embeddedness in legitimate expectation, necessarily because you simply cannot explain Mandalia otherwise. So there is nothing
Just to go back to
inconsistent.
just to go back to paragraph 29 of Mandalia. When Lord Wilson says the applicant's right to the determination of his application in accordance with policy is now generally taken to flow from a principle, blah blah blah. When he says generally, what authority is he referring to? Or is he simply extracting the generally from the passage that he quotes in Nadaraja?
Yes, I think he's simply extracting from Nadaraja.
Right, well, I'll just go back to the point I made originally, which is that Nadaraja is a case all about an individual who was saying, I've got a legitimate expectation that my case should have been dealt with in a particular way.
Yes, and Lord Justice Laws said in terms that this issue was not one of legitimate expectation, it was one of good administration.
Well, it doesn't matter how you label it. It goes back to the point that an individual that can expect his case to be dealt with in a particular way.
I'm simply repeating myself,
Yeah,
my lady.
Yeah, I think we've got your submission very clearly now.
So my submission is there have not been articulated or identified any reasons of principle not to apply a principled justification, or rather this doctrine, which rests upon a justification in principle that applies to all policies that constitute the exercise of governmental power, to all such policies. There is no principled justification for restricting it in the way that has been urged on us, and its divisional court itself did. So can I turn then to the submissions of Sir James in relation to the individual policies? I'm not going to go into detail.
We're not going back over them again.
We're not going to go through them again.
No.
I'm simply going to make some short submissions as to the relevant law in respect of these. So we accept that there are many policies. We accept that they cover wide fields, and we also accept that within those policies there may be provisions that simply are not ones to which the duty of compliance applies, because they're purely internal administration and concerned with employment, etc., in a way I've just touched upon. But the touchstone, ultimately, of whether or not a policy is capable of being given legal effect was identified by the Divisional Court at para 115 of its judgment in reference to the Friends of the Earth case. And the question then is whether or not it is a formal written statement of established policy, and it must be clear, unambiguous, and devoid of relevant qualification. Now, we accept that is the starting point, and the court is going to have to construe the terms upon which we rely in context and decide whether or not they have the meaning, because it is ultimately for the court, for which we contend. And that ultimately is a matter for the court, and in doing so, it is going to have to resolve one of the issues that plainly arises between us, and that's whether or not the use of should in the SGB or in the number 10 policy is simply the provision of advice, or is exhortation to mandatory compliance. And we submit it is the latter. And we, in footnote 22 of our skeleton, for your lordship's note, we refer to a series of cases in which the use of the word should has been held to require those to whom it is addressed to comply. Can I also ask the court to read Mr. Justice Chamberlain's judgment in the GLP case at tab 41, and in particular paragraphs 127 to 129. Sir James referred to this and to the Divisional Court's judgment in which it said it was less sanguine than he. But we submit that Mr. Justice Chamberlain, at paragraphs 127 and 129, gets the position right in distinguishing between, and the ability of the court to distinguish between those provisions which merely provide advice and those which require compliance. So we maintain our submission that these policies have the meaning and effect that we have submitted. Can I turn then to Dunn? It was, I think, Sir James's submission this morning that the Dunn note is really irrelevant. And we submit it's not irrelevant because it is purporting to advise ministers that they can use WhatsApp when, in our submission, the policies which they are purporting to summarise and describe make it clear that you can't. And to that extent, and to the extent that they're inconsistent, the court should make that absolutely clear so that those policies or advice can be rewritten in a way that doesn't create the risk of those who are subject to the policies that do govern their conduct acting in breach.
So what creates the priorities between those two policies if they're in conflict? As I understand your submission, is the fact that the SGB predates the Dunn note. Is that it?
No, it's the fact that the Dunn note is purporting to describe what the policies themselves require.
I see.
Can I turn to relief? On relief, let me just check that I don't have to say anything about the Cabinet Office guidance. No, I don't think I need to say anything about the Cabinet Office guidance. On relief, can I just turn briefly to our draft order? For our part, we are content if this court, and we understand the concerns raised by the respondents in this court, but if this court feels that it is not in any position and has not been put in any position to deal with the question of whether there have been breaches of these policies, then we simply would seek a declaration in relation to, as set out at paragraph 2A, as to the enforceability of the policy, and the Dunn note. or actually, yes, well, the done note could even be dealt with in the judgment.
Because the done note's not on your enforceable
No,
policy.
it's not there. And
And
that can be...
and it also doesn't say, and it's not enforceable in the draft order.
No, it's...
Unless I've missed it.
Well, no, we would be content if the judgment just addresses the done note, and we would be content with the judgment. But we certainly would want a declaration in relation to the enforceability of these policies. Can I turn to standing? I'm afraid I am going to inevitably have to take the court to some of the authorities that Sir James referred to but didn't take the court to, for which I apologise, but I think it is important, and it's certainly important, very important to GLP that this issue is addressed in full. So the ordinary rule, of course, and we refer to Hunt for your lordship's note, but this is there in our skeleton argument. But the ordinary rule is that if a declaration is sought, it will be granted, and that's Hunt paragraph 12, which is authorities tab 26. Page 952.
Thank you.
And we also address in our skeleton that the impact of standing on the exercise of discretion, and because this is in response to the respondent's case, relying on the judgment of Lord Reader, paragraph 95 in Wharton, that standing is relevant at the exercise of the court's discretion whether or not to grant relief. Page 761.
Sorry, just to go back to Hunt, there wasn't any issue about standing in Hunt, was there?
No, there wasn't.
So it's not
So I'm just taking that as the starting point.
No, okay.
I'm saying that's the starting and the end point. No, there was absolutely no issue taken about standing.
Right.
So that would be the ordinary position. And at paragraph 95, Lord Reed makes clear that, and this judgment is all about standing, the issue of standing may also bear upon the court's exercise of its discretion as to remedy, if any, which it should grant in the event that a challenge is well-founded. In that regard, I respectfully agree with the observations of Lord Carnworth at 103. And if we just look quickly at Lord Carnworth at 103, and if the court would just read 103.
I'm so sorry, I missed the tab reference. Could you repeat it, please, Ms. Kaufman?
The tab reference is 23.
Thank you.
And the simple point we make about this is that in this case, there are no competing interests or issues that would require the court, or if the court finds ultimately that the duty of compliance does extend to a policy of this nature, then there are no competing interests which ought to prevent the court from giving the ordinary remedy that would follow of a declaration. I then turn to standing itself and the correct approach. There are two Supreme Court opinions that have, in the last 10 years, endorsed a flexible, context-specific and liberal approach to standing. And we need to look at both of those because, of course, Runnymede cites those judgments and also has to be read consistently with them. And if it isn't consistent, it should not be followed. So AXA is tab 21, and that's the first authority. And the court can look at paragraph 63 the judgment of Lord Hope.
Page.
That's page 680.
Thank you.
4 lines down. One must, of course, distinguish between the mere busybody to whom Lord Fraser referred in ex parte National Federation of the Self-Employed and Small Businesses.
You read from the beginning.
Oh, like Lord Dunedin in Dundee Harbour Trustees, I would like to not like to risk the definition of what constitutes standing in the public law context, but I would hold that the words directly effective, which appear in Rule 58.8, capture the essence of what is to be looked for. One must, of course, distinguish between the mere busybody, to whom Lord Fraser, blah, 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 and the interests of the person affected by or having a reasonable concern in the matter to which the application related. The inclusion of the word directly provides the necessary qualification to the word affected to enable the court to draw that distinction. So that is a distinction between the mere busybody and a person who has a reasonable concern in the matter to which the application relates. A personal interest need not be shown if the individual is acting in the public interest and can genuinely say that the issue directly affects, in that sense, they have a reasonable concern, the section of the public that he seeks to represent. So, translating that to here, GLP is seeking to represent the public at large, which has a reasonable concern in securing transparency and accountability in the conduct of government business. Can we then turn to paragraph 170 in the speech of Lord Reid? And if I can ask the court to read that for...
How do we know that the public at large has got a concern in this? I mean, has there been an opinion poll or something? I mean, it's a rather grand, sweeping statement.
Well, my lady, we live in a democracy where one of the underlying principles of an effectively operating democracy is that in order to operate in the public interest, it must be transparent and accountable to the people, the government, to the people that vote for it. So it is to be taken to be a matter of general public interest. Or a matter
I
that
just
the
wanted
public
to know
are
what the
interested
basis of that statement was. So it's just to be taken as the case. All right.
Yes, it absolutely is to be taken to be the case.
Right.
I would be amazed if anybody would dispute that it is in the public interest that there be transparency and accountability, and a matter that the public has an interest in and is concerned about. Para 170.
Of AXA.
Of AXA, paragraph 170, page 714.
Thank you.
We see that flexibility throughout that passage. Flexible, context specific, and whether it is what is to be regarded as an efficient interest to justify a particular applicant's bringing a particular application before the court and thus conferring standing depends, therefore, upon the context, and in particular upon what will serve the purposes of judicial review in that context. Supervisory jurisdiction at the beginning of 171 has developed almost entirely through judicial decisions. One of the responsibilities of the courts is to ensure its continuing development on an incremental basis so as to meet the needs of the time. And if we then turn to the case of Walton, which followed on not many years later in 2012, and that's tab 23, the court again came back to the question of standing, and we looked at paragraph 95. Could we turn please to paragraph 92 on page 760 and read through to 94. And that quoted passage is the one we've just read in AXA, so the court will be able to skip quickly across that.
I'm so sorry, I'm several skips behind the beat again. Could you just give me a
Page 760, tab 23.
Thank you very much.
94 is very important. Particular significance, there may also in 94 be cases in which any individual, simply as a citizen, will have sufficient interest to bring a public authority's violation of the law to the attention of the court without having to demonstrate any greater impact upon himself than upon other members of the public. The rule of law would not be maintained if, because everyone was affected equally, was equally affected by an unlawful act, no one was able to bring proceedings to challenge it. At the same time, and we've dealt with 95. So,
May I ask just one point on that passage? I mean, it might be thought that the first part is directed to, for example, if your Potemkin case had had legs, then no one could sensibly argue that you wouldn't have had the standing to bring such a serious breach of the law to the attention of the courts. But on the other hand, you're pointing out that X used a WhatsApp and Y used an email on this date. That might be thought to be the other side of the line. What would you say about that?
well, precisely, it is incredibly context specific. So one of the factors that the courts consider is the gravity of what is being alleged. So in this case, one of the key objects and functions of this judicial review is to identify and determine as a legal matter the status of these policies, and then to look at the nature of the breaches, if any, that flow from it. So that is all part of the context that you have to take into account. But yes, it's incredibly context specific. Merits are very important, as Sir James has himself said. But the critical point about this is it is flexible, and there is no rule of law of standing that says an individual, simply by virtue of being an individual who has a sincere and reasonable interest, no different from any other member of the public, can in certain cases bring a judicial review. And that is a fundamental principle stated at the highest level. And Runnymede, in our submission, is in danger of, and certainly the respondents are in this case, are in danger of undermining and being entirely inconsistent with that judgment.
But those weren't the facts of Walton. So, I mean, there are some general statements in Walton, but the facts of Walton were that the applicant was an objector to a proposal. His group was represented by counsel at the relevant inquiry, and the applicant himself gave oral evidence.
Yes.
So I don't really understand why there was an issue about the applicant standing in that case.
The Supreme Court in both those cases were setting down clear statements of principle about the nature of standing, and I'm not sure that that's in any issue between the parties, that those statements of principle, and certainly that is how...
But the statements of principle have got to be read against the facts of the case in which they're enunciated.
Well, the statements of principle there are about how context specific the rules of standing are. So the facts of that particular case are in one sense neither here nor there. I'm drawing upon this authority because it is an authoritative statement of the principles that govern standing. Can I turn to tab 45 in the Runnymede case, on which the respondent places so much reliance? Can I ask the court to read paragraphs 20 and 21?
Do you have a page number?
Oh, I'm so sorry.
No, don't
1528 and 1529. I'm sorry, I keep
Yes,
forgetting.
don't worry. Thank you very much.
Yeah.
So those three categories are important, and they're important for our purposes. In our submission, GLP is bringing this challenge as in the public interest, and it's that third category of challenge. It's bringing it because of the interest the public in general has in transparency and accountability. So can we then turn, as we go through, we can see that the court cites AXA and Walton with approval. That's in paragraphs 24 and 25 and 26. And could we then stop at paragraph 28? And the court then refers to the DSD case, D and the parole board. It says, we also know that not everyone who has a strong and sincere interest in an issue will necessarily have standing, not even a public official such as the Mayor of London, who had an obvious interest in tackling crime in the operation of the criminal justice system as it applies to London, including in relation to support provided by victims of crime, and then refers to the D case in which the judgment of the court is cited at paragraph 11. The test of standing is discretionary, not hard-edged. One consideration which the court took account of and reached the conclusion was that there are, or would be, obviously better placed challenges. Now I'm going to come on to that in a little bit more detail shortly, but one of the points I will be making in relation to the obviously better placed challenger is that that is something that has significance either in circumstances where in the litigation that is currently already running there are other challengers who are obviously better placed, or it is relevant in circumstances where the decision in question under challenge is not one that is simply that is in the nature of decisions such as this and affects the public interest generally, but is one that directly impacts upon particular individuals more than others. So, for example, procurement decisions which impact upon the applicants for contracts, those who succeeded or those who didn't, but it is not applicable in relation to a pure public interest challenge, and certainly not applicable where there is no other challenger. So then, if the court can turn to paragraph 53, and we can see some of the challenges actually in issue in that case, in this case. Sorry, I'm having trouble with my computer now, my lord. So, firstly, there is the PSED challenge. So one of the grounds of challenge was a failure to comply with the public sector equality duty. And at paragraphs 55 to 56, in the present case, the question of the first claimant standing is a live issue, and so we will address in more detail than appears to have occurred in other cases. And then it looks at what the GLP is by way of a private company limited by guarantee. And it addresses, towards the bottom of that paragraph, the resolution was passed by Mr. Julian Morm, being the sole person. The company is established for the purposes expressed in the Memorandum of Association. And the current version is then referred to. And in paragraph 56, we can see at line 4, the current set of articles were drafted during 2021. They were approved by the GLP board on the 30th of November of 2021 and were formally adopted on the 15th of December of 2021. They were registered at Companies House on 20th of December. The articles define the objects of GLP as follows, and if the court can look at those, and then note in particular, paragraph 2.3, to uphold high standards in public administration in accordance with democratic principles. And then I would ask the court to read paragraphs 57 through to 59.
appellant.
So it's not clear whether the position of the divisional court there was that GLP can never have standing given its objects, or whether or not it is actually saying something narrower, which is those objects will not confer it on its standing in every single case. Now, if it's the latter, or if it's the former, we submit that that is wrong as a matter of principle.
Well, it seems to be the latter.
Yes, and if it's the latter, then the claimant readily accepts that it will not have standing in every case. There will be numerous cases where it will not have standing because of the nature of the rules of standing, but there will be cases in which the nature of those objects and the nature of the challenge in question, the decision, or rather, that is being challenged, will be such in which it is capable of having standing, taking account of all the other contextual factors that have to...
I mean, can I put it this way, that you say, if you succeed in every other aspect of this appeal, you say it would be bizarre if you didn't have standing, because this is obviously a very serious matter of public interest.
It's obviously a very serious matter of public interest. It is one that is in that third category, and therefore we are, or GLP is, in as good a position as anybody else. It is not a busybody. It has a sincere interest. See paragraph 2.3 of its objects. It has a sincere interest.
And the merits are important, and you'll have won.
And the merits are important, and we will, yes, and plainly, if we get that far, we will have won. Can I...
Before you leave that, Ms. Kaufman, may I just ask a question, please? You said that the claimant readily accepts that it wouldn't have standing in every case. Can you give me an example, having regard to the width of the objects in the memorandum, of a case where you would accept you didn't have standing?
So, for example, in a procurement case, as has been now been made clear in the Abingdon litigation, in a procurement case, you are not dealing with a public interest challenge, that third category identified in Runnymede. You are dealing with a challenge where there is a directly affected
All right, I get
individual.
that.
So, but those are important. Those
No,
are the
but
kinds of cases.
is there another example apart from the procurement case?
Another example. Let's take DSD. Let's take the decision of the parole board to release John Warboys. If PLP had come along and wanted to challenge the decision of the parole board to release John Warboys, the answer would be absolutely no standing. The Secretary of State for Justice is a directly affected party. The Secretary of State for Justice incarcerates Mr. Warboys. The victims of Mr. Warboys are directly affected by this decision. A decision about the stallholders in the market, for example, one of the cases we were looking at earlier. There are numerous cases where there is a directly affected person. There are the surrogate standing cases where, again, there is a directly affected group of individuals where PLP may well not be able to come forward and argue that they have standing. But the kinds of cases where it is much more likely that they are to be found to have standing are going to be those cases where the public interest in general is engaged within the arena or the sphere to which their objects apply. And what's of very great importance in evaluating or identifying the relevant principles is that there is no rigid rule laid down by the court that, for example, as the Secretary of State is seeking to have this court do in this case, where there is in fact no other challenger, but there may be people out there who have a more immediate interest in this case, such as journalists, that GLP should be shut out even though those journalists have not brought proceedings. That is a wholly impermissible basis upon which to shut out a claimant who has a genuine and reasonable concern about the legality of a decision where it is a public interest challenge. Because we can't know why others haven't brought those challenges. There could be all sorts of reasons why. What is critical is, do they, C. Walton, have a genuine, and AXA, a genuine and reasonable concern such that they are not a busybody?
Well, for my part, it seems to me to be really context specific.
It is.
If
That's
you were
exactly
bringing a challenge which succeeded in relation to one WhatsApp message by one official on one day many years ago, it might be said that that was not something you had standing to bring. If you, on the other hand, bring a systemic challenge to the way government operates, where everybody in the whole world is interested in the way you say, and you succeed in that, in showing what one might call serial illegality, then you might well have standing. I mean, the point is so context specific that we have to look at the context.
That is precisely our submission, and there should not be any fixed rules that constrain the ability of the court to look at all the relevant context, such as if there is a better place challenger, that's the end of it.
I mean, the important thing for us is to understand the law, and you've taken us to that.
I'm terribly sorry, GLP does not accept that it wouldn't have standing in procurement decisions, and that it is in the process, in fact, of seeking...
Well, I noticed the excitement on the left-hand side of the court and the horror behind you.
I apologise to everybody for misleading you. It all might be at an end. No.
What about Mr. Warboys? What about Mr. Warboys?
What about Mr. Warboys?
So you still accept you wouldn't have standing in Mr. Warboys'
Oh
case?
well, I would certainly accept.
Yes,
that
but
there
what
would be
about
no
those
standing.
behind you?
What's your view? No, I will make that tentative submission on behalf of GLP, but they've indicated they won't be judicially reviewing. He remains in prison at the moment, and so it won't be arising for consideration for some time.
I mean, the serious point is that it's context specific. We have the legal statements and the statements of the law, which we're not likely to try and overrule two Supreme Court cases as to what the law is said.
I'm grateful. Unless I can be of any further assistance, my lords, my lady.
Anything else? Anything else? Thank you very much, Ms. Kaufman. So, I think it only remains for us to say that we will not be giving judgment this afternoon. So we will reserve our judgments for a future occasion. When we hand them down, you'll remember the important terms of the embargo, so that the judgment is embargoed and only to be used when you have it in unapproved form for the purposes stated in the Counsel General of Wales case. You may use it, however, to try and agree an order and costs, and if you can't agree an order and costs, we will decide that question, but we will do so in writing. But I should thank counsel at all levels and solicitors at all levels on both sides for what has been a very, if I may say so, well-argued and important debate, and we'll obviously take your submissions very seriously and consider them